morning, everyone, and welcome to today's webinar, 15 Conveyancing Habits and Land Registration Issues. My name is Stephen Smith. I'm the Country Manager at Stewart Title Limited, and I'm delighted to be joined once again today by Ian Quayle, who will be leading today's session. Good morning, Ian. I think you'll all be familiar with Ian, but just very, very quickly, Ian qualified as solicitor and worked in private practice for 12 years, specialising in property law matters, generally including residential development work, commercial acquisitions and disposals. Obviously, Ian now is predominantly a trainer through IQ Training Limited, but and we're very happy that he's joined us on this series. I'm also joined today by my colleague Robert Kelly. Robert is the Commercial Business Development Manager at Stewart Title, having previously been a solicitor, department head and partner with over 25 years experience in the industry at a number of well-established firms. So Ian and Robert, good morning to both of you.
Morning.
Before we get started and the main part of today's event, I just wanted to very quickly, as per usual, just go through the control panel and how you can participate a bit in today's event. We've got some handouts, hopefully, that you can see on your screen. The main one of interest is the notes for today's session, but as most of you have been on the previous two sessions as well, just in case anyone didn't have the notes, we've also included the notes from those two sessions as well. As a reminder, and I will say this again later, but please do let any colleagues know if you think they would be interested in these sessions. We do have recordings online of them as well. On that note, a link to the recording will be sent out in the next couple of days along with the slides, and within that recording you'll also find other webinars from this series and other presentations that Stewart have done generally as well. So as far as the control panel is concerned, you're listening in by your computer speaker system by default. If you would prefer to join over the phone, then you can just select telephone. It may be that you're able to get a better connection doing that, but obviously it's not ideal. So that's in the audio pane section. You can click that. If you click on telephone, it gives you the relevant dialing information, and there is a toll-free option from those dialing in from the UK. You will have the opportunity to submit text questions to Ian and to Robert and myself in the questions pane of the control panel. You may send these questions at any time during the presentation, but we would advise that there will be a Q&A session at the end of today. So if you would like to keep any questions for then, we'll certainly have about 10 minutes at the end to go through those. If you're feeling brave, you also have the raise hand function. So if you raise your hand, you are able to actually ask a question over your speaker or microphone. Again, we would recommend keeping that to the end of the presentation, but that's an option as well for anyone that does want to ask a question. Anyway, that's really the sort of the technical parts of this. So without further ado, I will pass over to Ian for the main part of today's presentation. Thank you.
Thank you, Steve. Good morning, everyone, and once again, welcome to a webinar. Today, we're looking at some land registration issues and some good habits with regard to land registration and residential conveyancing. Before I sort of embark on my presentation concerning land registration, just a big thank you to Stewart Title for organising these events. I've been astounded as to the number of delegates for the events, and indeed astounded by the very, very positive feedback that I've received and Stewart Title has received. Significantly, a number of delegates sort of raised questions and issues, and I'm quite happy to deal with those. It's useful for me to see some of the questions and issues that are generated by the presentations, on the basis that I can occasionally come up with an idea or a solution or an answer to the question, or more commonly go scrabbling off to try and find a solution or answer to the question. So that's very useful. And as Steve mentioned, we've got the question and answer facility with regard to the webinar, but you're more than welcome to drop Stewart Title an email and we'll get it to me, or an email to me, and I'll endeavour to assist whenever possible. And I think the other thing to mention is that Stewart Title and myself are very keen to sort of promote training, both in these difficult times and indeed when normal circumstances are resumed. And again, therefore, if you have any ideas with regard to training or webinar content, do either let Stewart Title or myself know, and we'll see what we can do. So enough of that. What we're going to be doing today is looking at some what I think are important habits relating to land registration. Some of them will be, of course, known to you. Others perhaps won't. Where they are known to you, there are sort of nuances, there are sort of particularities and peculiarities that I want to sort of draw to your attention. The first thing I want to talk about are just some general habits about doing the simple things well. The vast majority of negligence claims against residential conveyancers arise as a consequence of a failure to do simple things well. The average value of a negligence claim against a residential conveyancer is £15,000. So frequently it's the sort of what I would class as the sort of obvious thing that's missed that tends to lead to a claim, not the sort of complex matter or the complex issue or something you've never seen before, because in those circumstances you tend to take a step back and have a long, hard look. We'll be talking about how to avoid negligence claims next week. Identification of client objective, always important, and of course making sure that clients understand what we're doing so that they can provide informed consent. Don't forget those sort of general good habits with regard to conveyancing process and procedure. The first thing I want to talk about is the requirement to be careful about land registry title plans. Don't know about you, Robert, but I wish I had £1 for the number of times I've looked at firms' standard procedures and processes relating to reports on title, and you see a reference to the fact, here's a copy of the land registry title plan showing your new property showed edged in red. Occurs all the time, and of course there is an issue. And the good habit I want to promote is the fact that yes, we should be providing land registry title plans to clients, but we should explain to them that the title plan needs to be dealt with cautiously. Section 60 Land Registration Act 2002, I'm sure you're all familiar with. A title plan reveals a general boundary, not a legal boundary. And therefore, if we have a client that's intent on using a title plan to demark the extent of their property, then there's a potential problem. Again, Robert, I don't know about you, but over the years, I've encountered lots and lots of situations with regard to boundary disputes. The worst one I can ever remember was some people who own a restaurant that we did some legal work for. And it's always the case, isn't it, on a Saturday evening or a Friday evening when you're out for dinner, and someone says, oh, hello, nice to see you, Ian, etc., etc., and the chit-chat, 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 and then it gets round to legal problem. Well, this particular problem arose on the basis that the clients had bought a lovely little cottage, and they'd been provided by their residential conveyancer with a copy of the title plan, and they decided that they didn't like the hedge that marked the western boundary of their plot. So they decided that the hedge would be removed and a fence installed. And I don't know why clients do this, but the decision to remove the hedge and install the fence occurred when a neighbour went on holiday. So surprise, surprise, neighbour comes back, Third World War declared, litigation ensues, and during that litigation, which these parties lost, the judge was sort of highly critical of the reliance that had been placed on the title plan. And again, it just sort of highlights the point. A good habit is to say to a client, there's a title plan, but be careful and cautious with it. You can't rely upon it. In the notes, I talk about boundary sensitivity, situations where there's a historical boundary dispute, alarm bells ring, where boundaries aren't identified, where title plans or ordnance survey plans don't accord with actual boundaries of the property, or where you've got a client who wants to develop land and wants to know where his boundary is. So I'm buying this property. The reason I'm buying it is I'm going to demolish the 1930s extension and I'm going to build a large extension. I need to know with some precision where my western or eastern boundary is, for example. The other point with regard to title plans that again can create problems is that the plan might refer to a right of way. And again, if the title plan is defective, then there could be an issue about the potential for a ransom strip at the point of access and egress. Fortunately, with regard to amending title plans, the Land Registry are fairly happy to amend a title plan to show dominant and servient tenement with regard to easements. They are very reluctant to amend title plans on the basis that the title plan is wrong per se. A case called Bradford and James sort of highlights that point. I mentioned on slide, and I mentioned in the notes, the use of property protocols, a website devised by two QCs and some city firms in London about dealing with boundary disputes. But that protocol is very useful if you haven't seen it, because it explains some of the issues that I'm discussing now, highlights how boundary disputes can be resolved, the use of mediation, for example, encourages the use of determined boundaries, which we'll touch on in a moment or two, and highlights that litigation involving boundary disputes is expensive and that there are significant cost risks. So, if we're looking at a good habit with regard to title plans, what does that good habit then entail? I've already mentioned one, there's the title plan, but proceed with caution in using it with regard to measurements, etc. Two, make sure client inspects target property and that you arm the client with information to enable the client to determine just what he or she is buying. Now, if you note in the notes, I'm quite meticulous about what I suggest the client should be armed with. Estate agent's particulars, which will contain a description of the property. The description of the property as per the property register or the route of title or other conveyances if the title is unregistered. A description of the property in the contract, particularly relevant if we're buying part of a garden. The title plan with the warning. If we've got a client who's had a survey or valuation that's to hand, make sure the client takes that with them when they inspect. And I think what we should be doing as a good habit is asking the client to report to us if any of the documentation that we've given them is inconsistent with other documentation, and is the entirety of that documentation consistent with what the client sees on inspection. Why am I so fussy and so pedantic about this point? Well, the reason is there's been some cases, a High Court case in particular, and a Court of Appeal decision too, where the court is saying if there's inconsistencies with regard to documentation, as to which of that documentation we'll prefer or will rely on, it's that which makes the most sense when we actually look at the ground or the land or the property itself. If we're producing plans, if we're dealing with sales of part, etc., if we're wanting a chartered land surveyor to sort of determine the location of a boundary, we can use national grid references. Land surveyors should be pointing that out to us, and our documentation can refer to those national grid coordinates, etc. That might be appropriate. We could make sure that as far as when dealing with unregistered land is concerned, we register it. Registration of unregistered land will not necessarily resolve a boundary issue or a boundary problem, but it will potentially flush out a boundary dispute. And finally, on this slide, in the notes, I talk about determined boundary applications. Determined boundary applications are brilliant where there is agreement between neighbours as to the location of boundary. The Land Registry will fix the boundary and put notice of determination on both of the titles, meaning that our client who wants to build his extension can do so with impunity, meaning that the client who's buying a property where there's been a historical boundary dispute need not fear about litigation ensuing relating to that dispute. So that's the fix. The determined boundary application is the holy grail where a client is dissatisfied with the title plan and with the position or status of that title plan. I mention and I emphasize determined boundary applications are brilliant where there is agreement. They are a nightmare where there is disagreement. The reason for that is that the Land Registry used to refer the matter to adjudication. They'll now refer it to tribunal in order to determine the location of the boundary. Both of those processes were not efficient. And therefore, a determined boundary application, great where there's agreement, nightmare where there isn't agreement. However, there is one situation where I would advocate a determined boundary application where there is a dispute. And that's, as I mentioned in the notes, to stop the clock ticking with regard to an adverse possession claim or potential claim. Finally, before we leave this particular issue and before we go away from this habit and look at another one, Land Registry Public Guide 19 used to be very useful. It used to contain information about plans and boundary questions. It's no longer available, but the information that was contained within that guide is available on the government website. So again, if you're not familiar with that, it's useful background information for clients to alleviate the problem that can arise relating to title plans. Robert, before I go on sort of any further relating to this, as far as product is concerned, as far as your involvement is concerned relating to sort of boundary issues and boundary problems, what sort of product does Stewart Title have that might sort of alleviate the problem or preclude the need to make a determined boundary application if, for example, there isn't an opportunity and there isn't the time to make such an application? Can you join me, Robert?
Yeah, I mean, it depends really, as with all these sorts of things. Are you looking at an adverse possession claim? You think you own it, or are you looking at a ransom strip? So in both cases, we can produce policies there. And that is one of the things where sometimes we will ask the lawyer that very simple question: what do you think it is? You know, because the same problem will arise, but sometimes you just need to think about what legal argument you're putting forward for it. So we can certainly provide policies there to give protection. And just when you were talking, Ian, I was thinking back to you being an even older conveyancer than you, back to some of the plans we used to draw up 20 years ago when there were no land registry rules on it. You know, when the thickness of a pen could make the difference between your neighbour's fence and yours. So it's no wonder that there are these problems out there, and really they'll carry on for a long time until we've got better plans from all the registered titles, because so many are now based on very poorly drawn ones.
Absolutely. Yeah, you bring back memories, Robert, to Friday afternoons, and out would come the coloured pencils, and off we'd go with a client and try to cobble something together and submit it to the land registry, and they'd be quite happy. I wish, to be honest, the good times would come back, because these days, as we'll see in a moment or two, with Practice Guide 40, you've got to have sort of all the skills of a sort of town planner, architect, etc., and skilled draftsman to come up with an appropriate plan these days. So interesting point there from Robert on the basis that there are products out there that can provide assistance. A question that sort of follows from that: how long would it take a determined boundary application to be processed by the land registry? I'm loath to sort of give you guidance relating to that, because it just depends, to be honest with you. But I have seen a determined boundary application being dealt with by the land registry within a week. But that was where obviously the parties consented, where a plan was produced that was Practice Guide 40 compliant, and therefore the land registry had a relatively easy task. You could enter into a formal boundary agreement rather than going down the determined boundary route. Again, there'd be an issue about quality of plan that's submitted annexed to that agreement. And again, with regard to a formal boundary agreement, the land registry will note that on the title. So again, that's something else to consider and to have a think about. Moving on from this issue with regard to title plans, let's talk about the plans that we submit to the land registry. Don't know about you, but it really gets my goat that the land registry produce plans that we can't rely upon, that are inaccurate, and that the land registry are very loath to amend. And yet, as Sir Robert was touching on here in 2020, any plan that we submit to the land registry has to be Practice Guide 40 compliant. So the habit is here to check that plans are Practice Guide 40 compliant. Now that can be difficult, because there's sort of examination of a sort of sophisticated plan that's been produced professionally can be quite a task. The better thing to do, the good habit, is to make sure that whoever is producing the plan is aware of Practice Guide 40. And again, I've had situations where clients have told me the amount of money it's cost them to get plans that are Practice Guide 40 compliant. For example, just recently, a commercial lease, and the debate about whether it should be registered or shouldn't be registered, the tenant insisting that it was registered with a separate title, therefore the lease term exceeds 7 years, we're automatically into the requirement for the lease plan to be Practice Guide 40 compliant, cost the client £1,500 plus VAT to obtain that plan. And again, as with commercial leases generally, the deal was that each side was responsible for their own costs. Conveyancers are being caught out in connection with relying on poor plans. The landlord in the situation I've just envisaged, or with residential leases, the seller with regard to a standard conveyancing transaction is under an obligation to produce a plan that is Practice Guide 40 compliant to permit registration, particularly appropriate, solely appropriate where the conditions of sale 5th edition apply. Also, what's your plans on purchases of parts? Because again, the plan might be defective, and again, I've seen practitioners tell me, well, if the Land Registry accept a plan that I've utilised in connection with an OS2 search, then the plan is acceptable to the Land Registry with regard to my substantive application. That is not necessarily the case at all. I mentioned in the notes that first registrations are being rejected on the basis that plans are not Land Registry Practice Guide 40 compliant. And again, make sure that the client understands the requirements relating to plans. They're properly scaled, that drawings are compliant with BS 1192, that as far as the plan is concerned, be careful about relying on ordnance survey plans. Ordnance survey plans may not be accurate and can create, if we're using that plan as the basis for the plan that we're submitting to the Land Registry. I mentioned where we're dealing with airspace, roof space, tunnels, where we're dealing with subterranean activity, again, there can be significant problems relating to plans. And again, it's important that plans are professionally prepared and that they identify the extent of the land that is being sold or acquired. So a good habit, make sure that we are familiar with Practice Guide 40, that those that are producing plans for us or our clients are familiar with it, and that we check that what's being produced for us and submitted to the Land Registry is Practice Guide 40 compliant, rather than being requisitioned and rather than delays occurring with regard to the registration process. A relatively simple thing to do, but a great habit to have. Restrictions are a pet hate of mine, a pet sort of subject of mine. It shows you really how sad I am, doesn't it? I'm really concerned about Land Registry restrictions for a number of reasons. Firstly, and historically, after the introduction of the Land Registration Act 2002, the Land Registry was pretty relaxed about what sorts of restrictions it would allow and would permit. After about 2006, 2007, the Land Registry sort of woke up and said, hang on a minute, we think restrictions are being abused. And therefore, there was a tightening on what restrictions could or couldn't be used for. Remember, as far as a restriction is concerned, it deals with the management of a disposition. If you look at the relevant practice guide that was amended in September 2019, the Land Registry emphasised or re-emphasised that in essence it controls or manages the registration following a disposition. So, good habit, if we're acting for a seller and there is a restriction on a registered title, have a look at it. Can the restriction be complied with at completion? Does it protect an interest in land? Does it blight a title on the basis that it can't be complied with? A restriction cannot blight a title. It must be capable of being complied with. The seller should check that, because there is nothing worse in the sort of haste to proceed to completion, and with all the turmoil that completion can bring, having to deal with a problem from a buyer with regard to compliance with a restriction, or a buyer identifying that they can't comply and therefore are reluctant or unwilling to complete. In the notes, I mentioned J.S. Singh against Leandre, which is a 2010 case, which is quite interesting and shows an interesting point. The court was saying really that is a restriction necessary or desirable for the purpose of protecting a right or claim? And the court emphasising that what the Land Registry should do is determine, is there a relevant right or claim that should be protected by a restriction, and then is it necessary or desirable for that restriction to be placed on the title? That's quite an interesting test and a bit of a deviation really from the land registration rules and the Act itself. When we're acting for a buyer and there's a restriction on the title, good habit, check the restriction. Is it protecting an interest in land? Is the restriction capable of being complied with? Have we seen the source document that creates the restriction? And does that source document define disposition? Peculiarly, although disposition is clearly what the Land Registry had in mind with regard to controlling or managing registration flowing on from disposition, the term disposition is not defined by the Land Registration Act 2002. It has been widely interpreted by the Land Registry, but I think what we should really do is be quite specific. So the wide interpretation that I touch on refers to any form of disposition except the registration of notices or discharge of legal charges. But where there is a wide interpretation of what a disposition is, if the source document is vague or ambiguous or doesn't deal with it or define it, then I hope you appreciate there is a risk of sterilizing titles on the basis that a restriction can't be complied with. I'm sure have all come across leasehold transactions where a consent or certificate is required from a management company, for example, to consent to an assignment, but the management company no longer exists at company's house. Well, in those circumstances, I've often been asked, do we have to apply to reinstate the company? Well, the important point there is to understand that restrictions are not cast in stone, as we'll see in a moment or two. With regard to a restriction, then, we need to think about the last point on this slide, namely disapplication, cancellation, modification. So there are lots of choices available. Important point with regard to this is the Land Registry will invariably point you in the direction, if a restriction is causing difficulty, in applying to withdraw the restriction. To do that, you need the consent of the restrictioner. Disapplication, cancellation or modification, if we look at disapplication and modification, the application can be made to the Land Registry to disapply or to modify the restriction if it can't be complied with. Disapplication, the Land Registry will look at evidence from you as to what attempts you've made to comply with the restriction, and if it is disapplied, notice of disapplication is put on the title, and the disapplication applies for the current disposition only. The restriction resurrects itself for later dispositions. With modification, the modification is permanent, but with modification, the Land Registry will normally make their own investigations to see what the problem has been relating to the restriction. In the notes, I've given you more detail, and I've also mentioned Section 77 of the Land Registration Act 2002. Whenever you're dealing with notices, restrictions, or cautions against first registration, and there's an issue as to whether or not the notice, restriction, or caution should have been lodged at the Land Registry, do think about Section 77, because this imposes a duty on an applicant to have reasonable cause to lodge their application and to place whatever they're placing on the title or lodging whatever they're lodging at the Land Registry. It only applies to notices, restrictions, or cautions against first registration, but is a very useful weapon in an armory where a restriction or notice has been placed on a title that cannot be complied with and that shouldn't have been placed on the title in the first place. The test of reasonableness occurs at the time of application. Which leads me to the next good habit. Promise me that whenever you're dealing or protecting an interest in land and you're dealing with an applicant, that your first port of call will be an agreed notice, not a unilateral notice. The Land Registry were amazed when the 2002 Act went live as to the amount of unilateral notices that were being used and the very limited circumstances in which an agreed notice was being used. Why were they surprised? They expected unilateral notices to be used sparingly and agreed notices to be the common way of protecting an interest in land. Why was that not the case? Because the Land Registry called an agreed notice by the wrong name. An agreed notice implies agreement. An agreed notice implies that if I can't get agreement, or I can't be bothered, or circumstances are such that I don't want the proprietor to be asked if they agree to what I'm doing or not, then the default position must be I'll use a unilateral notice. Where there is no risk or challenge or problem with regard to the interest in land, it doesn't matter what you use. But if a unilateral notice is going to be challenged, if it's vulnerable, then an agreed notice is far better choice for the applicant, because an agreed notice is not subject to the same procedural challenge that a unilateral notice is. I'm not for the life of me saying don't use unilateral notices. I am saying if you can, if at all possible, use an agreed notice. And an agreed notice does not need the agreement of the registered proprietor. In the notes, I refer you to Rule 34.3 of the Land Registration Rules 2003. And in particular, I refer you to Rule 34.3c, which states you can lodge an agreed notice at the Land Registry if the land registrar is satisfied as to the validity of your client's claim to have an interest in land. So significantly, agreed notices do not need the agreement of the registered proprietor. Given the fact that an agreed notice can't be challenged, surely a good habit is to say, let's use an agreed notice first, and only if we can't use it do we think about a unilateral notice. To satisfy 34.3c, we would have to provide the land registry with evidence that we have an interest in land. So we've exchanged contracts today. Copy contract, copy memorandum of exchange, there's your evidence. Option agreement, there's the option agreement. Other interest in land, there's the documentatory evidence in support. Then we're going to get our agreed notice, even though the registered proprietor doesn't consent. The trap that some conveyancers fall into, as I mentioned in the notes, is that they think agreed notices are only available in very limited circumstances. The point I'm making today is that they are far more widely available. Now let's just turn this on its head for a moment or two. If I'm a registered proprietor and someone is generating an interest in land, I might not want an agreed notice on my title because it's going to be hard to shift once it's on the title. And therefore, a good habit from a selling perspective is to put a contractual provision, a special condition in our contract, stating that the buyer can't lodge an agreed notice on our title. You might think, well, obviously we've got an inconsistency here, and clearly we have. The sort of halfway house is for a seller to say you can't have a unilateral notice on your title. Sorry, you can't have an agreed notice on our title. You can have a unilateral notice on our title, but that we won't challenge it, or more accurately, the registered proprietor won't challenge it. Significantly, the seller is not being particularly generous with regard to that accommodation. The reason is that it is not just the registered proprietor that can challenge a unilateral notice. That's why a unilateral notice has this incredible amount of vulnerability, because it can be challenged by the proprietor of any charge on the title, anyone with a prior registered notice on the title, or any other potential interested party. A very wide-ranging group of people can challenge unilateral notices. One particularly important habit to be aware of is if you are protecting an interest in land sometime after the interest in land has been created, the fact a unilateral notice can be challenged is significant, because if it is challenged by litigation, a High Court or County Court judge can not only remove the notice, but also insist that nothing is placed on the title in its place, in essence granting an injunction to stop anything else protecting the interest in land that was protected by the unilateral notice. So you exchanged contracts 6 months ago, you then realize today that you didn't protect that interest in land, you today register a unilateral notice, that unilateral notice will be vulnerable to challenge, and the court could determine that you can't put anything else on the title when that unilateral notice is removed. A case called Donnelly against Weybridge Construction deals with that issue. Donnelly and Weybridge Construction, just as an aside, interesting case as to what not to do in a property joint venture. Have a look at it if you've got time. It's quite a funny case, to be honest with you, quite an interesting case from a number of different perspectives. With an agreed notice, the land registry is not obliged to serve notice on the registered proprietor, even when the application is made without the proprietor's consent. You may say, well, hang on, Ian, if I've got to submit documentary evidence in support, there's a confidentiality issue. There's nothing to stop you applying for exempt information status to the Land Registry for any documents that you're submitting in support of your application for an agreed notice. In the notes, item 5, I say, remember that we can challenge unilateral notices. As far as that challenge is concerned, I've identified who can make the challenge. It's a relatively simple process. And as far as challenging unilateral notices are concerned, there's also a fundamental point, namely, a notice on a registered title does not validate or legitimize an interest in land. Therefore, if someone places a unilateral notice on the title, think about challenge, but also think about the more fundamental point: is this notice actually protecting a valid or legitimate interest in land in the first place? If not, then it is certainly vulnerable to challenge and the notice should be removed. I've set out the process. It's fairly self-explanatory, to be honest with you. I've also mentioned some other safeguards that are available where unilateral notices are placed on a title. Firstly, the submission of the form could amount to a fraudulent misrepresentation that's a criminal offence, Section 1 of the Fraud Act. It's a breach of Section 77 of the Land Registration Act, as we've mentioned, and I've given you some case law relating to it. And I've also mentioned that there is a possibility for the Land Registry to cancel the unilateral notice, if possible, details in the notes. Which leads me to habit number 6. Be aware of Section 77 of the Land Registration Act 2002. Very rarely used, most practitioners are not aware of it. Useful if there's a caution against first registration that's unjustified, if a notice has been placed on the title and is unjustified, and it can also be used to challenge any objection made to an application to the Land Registry. For example, if an objection is made to claim for adverse possession. Very useful provision. Labatier and Mornington Estates highlighting the fact that it can be utilised to challenge the use of a unilateral notice to protect, for example, an exchange of contract. And now I want to talk about habit number 7. But before I do that, Robert, can you just let me know and let the delegates know about what products are available relating to adverse possession issues? Don't know if Robert's with us.
Sorry. Yes. There are a number of policies there. Obviously, an adverse possession policy, we would be looking to see some evidence of how the land has been occupied. Traditionally, we've talked about it being fenced, but as you'll know, recent cases, I think the Thorpe and Frank last year made it clear that you can produce evidence by changing the land into permanent character on there, so fencing isn't required anymore. So when we get an application for an adverse possession policy, really the key is to give us as much information, that's photographs, that's history of what's being done, to protect the application there, to show us what's needed. And these are policies which we can write fairly easily. In many cases, they are available through self-issue on our online system as well.
Right. Thank you for that, Robert. Yeah. I mean, Robert makes a good point there about people often say to me, well, the land hasn't been fenced off. That isn't a determining factor. It helps if it has, but it's not something that would unduly concern me if we've got evidence of some form of change with regard to land usage, as Rob mentioned. The good habits that I want you to be aware of relating to adverse possession are as follows. Watch adverse possession relating to neighbour encroachment. Important to understand that Schedule 6 of the 2002 Act makes an adverse possession claim a relatively simple task. Second point, watch where there's been an adverse possession claim, where that claim was made but was unsuccessful. If the adverse possessor remains in situ, then he or she can make a further claim and is just about bound to succeed with regard to that claim. In short, if there's been an adverse possession claim, the buyer should check what's happened to the adverse possessor. Is he still in occupation? Alarm bells ring. Has the position been regularised by the granting of a lease, for example? We're not quite so concerned. Have proceedings for trespass begun? again, that would preclude the making of a second application. But if our adverse possessor is simply sitting quietly, then there is a potential risk for a second claim being made and that second claim succeeding. The other point that I think sort of flows from this is to make sure that clients keep addresses for service up to date so that the Land Registry can contact them in the event of an adverse possession claim being made, because in essence it is that counter notice procedure that the paper title owner makes that really gives the Land Registry an opportunity to have a long, hard look at the adverse possession claim. Historically, a lot of adverse possession claims have gone through relatively easily because the paper title owner hasn't challenged or done anything about it. Which leads me to the last good habit. If you're ever in a situation where land has been lost due to adverse possession, remember that rectification is possible at the Land Registry in order to gain the paper title back. Standard limitation rules apply relating to that point. The next point that I want to look at, if I can, are addresses for service. Promise me, great habit to have, last letter to the client. Mr. Client, we've completed your purchase, we're closing our file, but you are obliged to keep your address for service at the Land Registry up to date. You can have 3 addresses: email address, correspondence address, address out of jurisdiction. But it's your responsibility to keep your address for service at the Land Registry up to date, so that notification of notices, rectification, adverse possession claims are going to be drawn to your attention to enable you to react. There is the potential risk of a negligence claim flowing against your firm if you haven't advised clients of the need to keep their address for service at the Land Registry up to date. Very important. Email addresses, very useful. And as we'll see in a moment or two, there is an additional habit relating to addresses for service when acting on a sale. And again, we'll look at that a little later. Habit number 9, and advice about cautions against first registration. Simple point this. Make sure clients understand if you are instructed to or decide to put a caution against first registration on unregistered land, that the caution doesn't protect an interest. To be supermarkets against Olympia Homes, not in the notes, but highlights the potential problem. It's an early warning system. The cautioner needs to know how they object to registration and the need to object to the registration process. Again, you may have placed a caution against first registration and then sort of obviously thought nothing about it, being aware that the client is going to contact you if anything arises. Well, I think we've really got to highlight that point and make sure the client needs to understand what they've got to do and needs to understand that they should be taking immediate legal advice if they're not intent or not competent in dealing with the matter themselves. So a relatively easy point to deal with. Another relatively easy point, but again, a good habit, an important habit. Prescribed clauses. Great things in essence, providing the Land Registry and HMRC with a checklist with regard to the provision of information, so they can easily source the information that they require from the leases that we submit. Prescribed clauses introduced is as an alternative to what the Land Registry was thinking about, which is creating a standard form of lease that practitioners would have to use. Some good habits to form with regard to prescribed clauses. 1, make sure that the draftsman that creates the lease, and you, if you're acting for a buyer, check the lease and prescribed clauses for consistency. So if there are easements in the lease, are those easements referred to at prescribed clause 11? Are the relevant title numbers of servient titles included within the prescribed clauses? If you do that, the easements will be automatically noted against those relevant servient titles. If not, then there's a potential problem and some vulnerability. Secondly, you might sometimes see a reference in a lease that's in prescribed clause format to another document. The Land Registry will want that document to be provided. Do make sure, of course, again, that you avoid general referencing. The idea of prescribed clauses is the Land Registry is being shown the information and where it's located in the lease. There's a sort of a follow-on point with regard to that I want to share. the land registry under no responsibility or no duty to check the information that you have produced. Sorry, I've just skipped a few slides there. They are simply under an obligation to extract information from prescribed clauses. So if there is information missing in the prescribed clauses that's contained in the lease, the land registry don't have to highlight that point. They may spot it and may draw it to your attention, and they've also got some limited jurisdiction to carry out administrative amendments to the lease or prescribed clauses, but these are very limited in scope. So again, good habit, be cautious about prescribed clauses. Next thing I want to pursue is the issue of land registration and digitalisation. Have a look, please, at Practice Guide 67A, some lockdown issues there with regard to client identity. There's also an issue now with regard to the fact land registry are willing to accept signatures that aren't wet signatures. You need to be aware of that. And also, again, a good habit, do have a look, if you haven't already, at how the land registry has promoted and indeed developed the idea of digital mortgages. Digital mortgages are useful. I was very worried when they were first introduced on the basis that there'd be an additional responsibility on conveyancers to sort of verify client ID. Fortunately, the technology is such that the position is that the borrower utilizes the identity processes established by the government, and therefore, to an extent, our potential responsibility and liability has been reduced, although we're still under a duty, of course, to explain to clients their issues and problems associated with client identity. I want to talk now about habit number 12 concerning overriding interests. Important point, clients should be told about the need to highlight to you any overriding interest that they identify on client inspection. Therefore, I think a good habit is to explain to the client what an overriding interest is, give them examples, explain to the client the fact that as far as overriding interests are concerned, they're not noted on the title, but nonetheless binding on the client. And also, I think, to be aware of the fact that if there are overriding interests that exist at completion, the buyer client, as the applicant for land registry purposes, is obliged to submit Form DI. If the buyer fails to do that, then there is a risk that if a claim for rectification is made against the title at a later date, and the rectification claim involves some aspect of an overriding interest that was a disclosable interest that should have been disclosed to the land registry will maintain that the registered proprietor had not behaved reasonably and would lose the right of veto that they have with regard to a rectification claim. So good habit, make sure that we deal with overriding interests so that clients, going back to my preliminary point, have this idea of what they need to be aware of to consent to the transaction progressing. The client needs to be aware that they have a duty to you to tell you about overriding interests that they see at inspection. Remember, with regard to client inspection, things that are actually seen when they inspect are binding on the client. Things that they should have seen had they carried out a reasonable inspection are binding on the client. Constructive notice, and there's also imputed notice if a third party surveyor or valuer, for example, examines, and if they are aware of an overriding interest, that potentially is binding on the client as well. I've given you detail relating to all of that within the notes. I have to say, overriding interests are not the most thrilling bedtime reading, but if you do have a look at them, there's a bit of background. The habit is the point that I make on slide. So there's quite a bit of information in there relating to overriding interests. I want to talk about mines and minerals, if I can. Robert, again, in the residential context, the moment a client advises that they have some form of subterranean activity planned, then clearly mine and mineral issues can arise. I've seen this, for example, with a developer that was going to put pile foundations into a site, and in doing so, trespassed against the church commissioners that own minerals beneath the surface. So it's not necessarily an academic point. It has the potential to cause problems for residential conveyancers. If, for example, where a client is going to build a swimming pool, where a client is undertaking some form of basement activity or basement extension. So, Robert, again, does Stewart Title have any sort of mine and mineral products that you could talk about or reveal to the delegates?
Yes, I mean, exactly that point is one of the main ones, the trespass, because in so many cases, reserves can be very shallow. So actually, you don't need to do a great deal of digging to trespass. So that tends to be, and of course, you can get a bit blasé really when you are looking at a building, a house in the middle of a well-developed area that nobody is actually going to work those reserves. Nobody's going to come on and start dispossessing you of the land. But the trespass one is a real issue. And when you have people, a lot of these interests held by people like church commissioners and so on, who are very active in enforcing their rights. So we do have policies there. Sometimes it may be just that you'll want to tick it off, particularly for lenders. So we do have lender-only policies there, which may satisfy them where your client, properly advised, feels it's not a risk for him.
Yeah, thanks for that, Robert. Yeah, I mean, this is something that you're not going to encounter as a residential conveyancer on a daily basis. But if you do, it is important that you understand and appreciate the fact that due diligence is required relating to mines and mineral rights, and the fact there are policies in the market that are available to protect you. But also the other thing that I think is important, that geological searches and geological reports might be appropriate if we're really concerned or we really have a sort of risk-averse client who's intending some form of activity that's going to involve subsoil activity or construction or deconstruction or excavation works. So again, just something to be aware of, a good habit to have. Again, sort of dealing with a basic point, explaining to the client what it means if we acquire the surface to a piece of land. In essence, we become the owner up to the heavens and to the core of the earth, but then there are a significant amount of restrictions with regard to that sort of common concept. The other thing is that, again, just as a sort of a development in this point, just because mines and minerals aren't registered doesn't mean they don't belong to someone. And where mines and minerals are excluded from the surface title, they potentially do and will not lose those rights simply because mines and minerals rights have not been registered. I want now to look at habit number 14, if possible. And this is rectification. The point here is the Land Registry title can be rectified. Schedule 4 of the 2002 Act is the relevant piece of legislation. The register can correct mistakes. The register can also, if I just make a note, remedy or rectify the title where there's been some form of mistake. The title can be rectified in order to incorporate within the title some interest in the land that the Land Registry is of the view should be incorporated within the title. The registered proprietor has a right of veto, but the courts and the Land Registry have a discretion to rectify if it is in the interest of justice to do so. So just because I, as a registered proprietor, don't want my title to be registered would not prevent the Land Registry from making the rectification. Important to understand that that right of veto only exists if the registered proprietor has behaved reasonably. If there's any element of fraud or lack of proper care, or the registered proprietor has caused or contributed to the mistake that is now being rectified, that right of veto is lost. That ties in to the point I made about adverse possession claims and the fact that we could use rectification to remedy the loss of a paper title in limited circumstances. Robert, again, if I may ask you, you will have alternatives to rectification. You'll have, I guess, a wide raft of policies that potentially would be available, rather than someone having to make an application to rectification with all the costs and issues associated with it.
Yeah, well, actually, probably in those circumstances, we might well say to you, where there is a clear remedy and a route available there via the land registry, that is the best route to follow. Because what we try to do is where it is difficult or impossible for you to resolve it, but here there may be a delay and there may be a cost, but actually it's got to be the best route for everyone to actually at least try and exhaust that route first.
Yeah, where that is exhausted, though, you'd have product available subject to the sort of the disclosure issue.
Yeah, exactly. So I mean, would need to know what applications have been made there and to consider it in the round, but there is always something available there to be looked at, almost certainly there on a bespoke basis. So again, we'd need an application and a lot of information from you.
Yeah, Robert, just throwing this into the mix for a moment. If I was contemplating rectification, concerned about disclosure issues, what would your stance be if I contacted Stewart Title and said, hey, look, this is what I'm thinking about doing? And if I was thinking about getting counsel's opinion on the point, would, rather than me get counsel's opinion, then ultimately have to go to you for you to issue a bespoke policy, and you then thinking about counsel's opinion, would you be happy if I said to you, which counsel are you likely to use, and I'll use them? So I'm killing two birds with one stone. I'm getting advice about what I should be doing relating to rectification, but at the same time, I'm potentially arming you with an opinion that you'd value, where you're looking at a bespoke policy. What would your stance be or view be with regard to that sort of approach?
Yeah, no, we'd certainly always try and work with you, and we can make recommendations of people we think who could give the best advice on there. But I mean, again, ultimately, it is something for you and your client to be happy with.
Yeah, it's just I had a situation years ago where I got an opinion from a barrister, went to an insurer. It wasn't Stewart Title, by the way, and they said, oh, well, we want an opinion from someone else. And the client's attitude to me was, well, what on earth were you doing? Why did you go to Mr. X when the insurer is now saying we need to go to Mr. Y? In that particular case, the client's attitude was, I'm paying for both. And I thought, well, yeah, that's a fair point. So that's interesting. And again, a good practical point. So good habit, do be aware of the Land Registry's powers to rectify defects in title. The only caveat, the only cautionary tale I would put forward at this point is that rectification of title plans is difficult. I've had situations where a client of mine has owned 3 parcels of registered land, so we own all the land around. There clearly has been a defect with regard to the creation of a title plan, and what you've had is a tiny sliver of unregistered land between 2 titles that we own. And you ask the Land Registry, please rectify one of our titles and the title plan to incorporate this additional area. And although not a uniform response, a fairly common response is, no, we can't. What you need to do is wait 12 years and bring a claim for adverse possession to a piece of what is unregistered land. I have seen some land registry officers take a very pragmatic approach and remedy a title plan to incorporate the land into a title, problem solved, but frequently they'll say no, adopt the other approach. The idea is that rectification in those circumstances isn't possible. Both the Land Registry and the courts have said on a number of occasions, why do you need to amend a title plan? It might be wrong, but it doesn't matter, which is an interesting stance, a rather infuriating stance, as you can imagine. The final habit that I want to talk about today is something that's very, very important. And again, it's important because of the potential vulnerability that you and I have as conveyancers relating to fraud. On the basis that if there is fraudulent activity, we don't need to look any further than Dreambar and Misconduct and a raft of other cases that highlight the potential for liability. Land Registry originally issued Public Guide 17, which I used to like, to be honest with you, and recommended that every firm sent a copy of Public Guide 17 to every client. on the basis that it generated a lot of useful advice and highlighted the potential vulnerability to fraud. Again, Public Guide 17 no longer available, but the information that it contained is available on the government website. The idea about registering and registered land, keeping addresses for service up to date, as we talked about earlier, registering double L restrictions. The theory of a double L restriction I like, the idea that a conveyancer has to verify that their client is in fact the registered proprietor, but again that can create additional vulnerability for the firm that is verifying proprietor ID. So there are some firms I know that are a bit reluctant to utilise or recommend the use of double L restrictions. The Land Registry has a variety of different measures to prevent fraud. I've given you some details. Again, just be aware of it and just make sure that we're advising clients about what they can do, the Land Registry fraud hotline, etc. The fact that our client may receive communications from the Land Registry about suspicious activity. And the final habit that I want to draw to your attention today, if I may, Steve and Robert, is this. Promise me that whenever you're acting for a seller who is selling registered land, the moment you download official copies of the register, you will check that there is a connection between the client's contact details that they've already provided to you and their address or addresses for service at the Land Registry. So I instruct you, I give you an email address, I give you my home address, you download official copies of the register. Surprise, surprise, there's a different email address and a different correspondence address. Why on earth is there a discrepancy? There may be a logical reason. I may have a number of email addresses. I may have a business address and a home address, but you've got to ask the question and alarm bells have got to ring. Certainly, if you were to act for a seller that's given you contact details and then their address for service differs, you must be incredibly suspicious and very keen to ask questions. And if you don't get satisfactory responses, then my view and my advice is you run a mile. Stephen, I'm conscious of time. I hope that's been of use and of interest to delegates. There are lots of things that I've touched on that may warrant additional questions. You may require sort of clarification or amplification of some of the points that I've made. I'm happy to take, Stephen, if I may, those questions now, or delegates can email me with any questions or queries, either through yourself or through my email address, which is shown on the last slide there. Before, Stephen, I hand over to you, can I thank everyone for listening today? Can I thank Stewart Title for sorting out these events and these webinars, which I hope have been useful and interesting. And I will make myself available now, Stephen, to any questions that anyone has.
That's very kind, thank you, Ian. And yes, I'm very sort of cognizant and aware of the time as well.
Yeah.
Just very quickly before moving to questions and realising that some of you will want to get off, we did just want to run a quick poll. We have been delighted with the feedback that we received so far on the series, so thank you very much to everyone that has given us that very positive feedback. Basically what we'd like to know is, are you interested in hearing more information about training courses that we can provide for your team specifically, and also for your support staff? So I just want to run that poll very, very quickly. I'll just launch that now and give people just a couple of seconds to fill that poll out. I won't dwell on it too much. We've had nearly 50% of the audience vote, so I'll wait till we get to about 60 and we'll close that off and I'll share the results there.
Thank you.
So yeah, I think let me just share that there. I think thank you so much for that. I mean, that seems sort of overwhelmingly positive that you would like more information. We'd be very, very happy to provide that. As I say, the feedback on these has been very, very good, and we are looking to extend the series. There's one more webinar left next week on this current series, but we will be extending the series beyond that due to the great feedback we've had. So Ian, just moving very quickly to questions. I won't cover off everyone. We've had a number of questions actually, which is great.
Yeah.
just focus on a few. If I don't get around to the question you've asked, we will definitely contact you and respond privately to that question. So just going, there's a few that came early on in the presentation. So Sarah Edwards asks, can you send a plan to the land registry to check it is acceptable before we make an application? Sorry, Ian, are you there?
There isn't a sort of a facility that enables. Can you hear me, Stephen?
Yes, yeah.
I think what's being asked is it possible to get pre-application approval with regard to plans? And this was something that was mooted by practitioners to the land registry, and the land registry were fairly receptive to it, but there isn't anything, in fact, in place as yet. It's the responsibility of the applicant to make sure that plans are Practice Guide 40 compliant. The land registry will reject. You can speak to some officers and get some sort of ad hoc informal advice, but the land registry will be reluctant to provide any formal advice pre-application.
Yeah, no, I think that answers the question, Ian. Thank you.
Yeah.
Yeah, so the second question is, if a property has unregistered title and there is a plan in the root conveyance, say, of 1983, how do you provide a land registry compliant plan if land registry will only register what is shown on the 1983 conveyance plan, which leads to the title plan omitting land considered occupied by the property but not in the title compared to the OS map?
Yeah, major problem, Stephen. Great question. Again, you'll get some land registry officers that are very pragmatic and won't insist on a Practice Guide 40 compliant plan. I've seen other land registry officers that will requisition and insist that a Practice Guide 40 compliant plan is submitted with the application, in which case the important point there is to make sure there is consistency with regard to the plan annexed to the conveyance and the plan that's been professionally prepared. It is the seller's responsibility to make sure that the buyer can be registered with a title at the land registry. Conditions of sale, 5th edition, make that a condition that the title is registered as an absolute title. I think that covers that one off, Steve.
Yes, yeah, absolutely. Thank you, Ian. Apologies if I pronounce this wrong, but Manib Mirza has asked, in relation to title plan boundaries, is it sufficient to merely advise a client to obtain advice from a boundary surveyor in order to be satisfied with the same?
Great question. Have a look at property protocols, because that sort of highlights the potential dangers of instructing a chartered land surveyor. A chartered land surveyor is only as good as the information that's provided to them. The protocol highlights what a chartered land surveyor should do in order to produce a plan or a report relating to boundary. There is nothing wrong in advising a client of the need to instruct a land surveyor to deal with the complications associated with identifying legal boundary. But at the end of the day, you might get a chartered land surveyor whose report is relatively worthless on the basis that they haven't got or had all the information they need to reach a conclusion, or a situation where they're unable to reach a conclusion as to where the boundary sits. They may give you a sort of a spectrum within which the boundary potentially sits, but not a precise location. Because at the end of the day, a boundary is a pencil line between two registered titles. It's that sort of minuscule. So any sort of line on a plan becomes potentially useless, really. Therefore, a determined boundary application is probably going to give you a more accurate fix and probably going to be better going forward on the basis that it is a land registry fix as to where the legal boundary sits going forward. So you might pay £2,000 or £3,000 to a chartered land surveyor to produce a report, and his report or her report may be inconclusive, in which case you're back to square one again. That's why I'm a bit reluctant about using chartered land surveyors. That's why I'd rather agree a boundary with a neighbour, get a land surveyor to produce a plan saying this is what we've agreed the boundary is, then make a determined boundary application. Okay, Steve?
Yeah, excellent. I mean, I do remember myself reading once. I might get the measurement wrong, but it emphasised the point that the nib of a pen on a plan, I think, can be up to 4 foot in real
Yeah,
life. So how do you identify that? Absolutely.
and a red line or a black line can be 3 meters wide.
Yeah, absolutely.
Yeah, yeah.
Yeah, I'd say a couple more. Apologies to anyone that we didn't get through to. I'm conscious that we're running about 10 minutes over. So I'll do 2 more questions, Ian, and I think we can take the rest offline and contact people individually. So Zara asks, with unregistered land, most are tempted to use old conveyancing plans as transfer plans. Would you advise that new plans are drawn up?
Yes, I would. Yeah.
I think that's a pretty straightforward answer there. And then one with regards to ID. So we have from Stephanie. Stephanie asked, regarding ID at the present time, are we okay to use ID digitally and verified using a credit card checker online, or credit checker online, sorry, without viewing original passport and driving license, etc.?
Yeah, look at there's some guidance, particularly from the Land Registry on that. It's prior to lockdown, I was highly critical of firms that would go on Skype and have their clients sort of produce a passport and that sort of as evidence of ID. But there's been a relaxation with regard to how we verify. Look at the Law Society guidance and also look at what the Land Registry is saying. Again, just because we're in extraordinary times, there is still the duty and obligation to verify ID. I would always want at least 2 separate sources for the ID information that's coming to me. So I could do an online check and get a client to Skype and to reveal documentation within that process. I would be very careful about recording what I've seen, or if I can take a sort of screenshot of the information that's being disclosed via Skype, etc., just so I've got evidence on file to support what I've done or to justify what I've done.
Fantastic,
Okay.
thank you, Ian.
Stephen, so if I can just interrupt there just very quickly, there are now products available, apps available that are AML compliant that use a combination of digital ID technology, but where people can take a photograph of their face and passport, and then it's matched up. They are available and they are now regarded as being compliant. So it is possible to onboard clients remotely now.
Yeah, good point, Robert.
Excellent. Well, thank you both, and thank you again to everyone that's attended today. If you have any other questions, and again, apologies, there's been 3 or 4 of you we haven't got round to, but if you have any other questions, please do contact me. If you respond to the email on your the webinar communication you've got, that comes directly to me. We're in communication with Ian all the time, forwarding on the questions and the feedback that we get. So we'll be looking to respond to that. As I say, we have one more webinar in the series, and we will be sending that. If you are interested in signing up and you haven't seen that, please also let us know. And if you have any colleagues that would be interested, we're very happy to do that as well. Also, just any general feedback that you have, we're very happy to hear that, positive and negative. But just to wrap up, on behalf of Stewart Title and Ian Quayle, I'd just like to say thank you again for joining us today, and have a great rest of your day. So thank you, Ian, and thank you, Robert.